If it's not down in writing, it's not going to happen. And other people are going to end up being in charge. So get it down in writing.
Thank you so much, Jane, for having this conversation with me today. And also, I feel like what you do is so vital. I've worked with you years ago when I first moved out here, and I think that what you do is amazing. And I admire your commitment to helping people better their lives as they age and like all their other stages of life. So thank you for what you
Absolutely. And thank you.
No problem, no problem. So I would love for you to just tell us a little bit about yourself and your practice.
Sure. So I've been practicing about 31 years, private practice in Ann Arbor. The practice has grown considerably over those 31 years, but we focus primarily on changes in life. So whether that's aging, disability, adoption, or wanting to start a family through artificial or assisted reproduction, I shouldn't say artificial, assisted reproduction. And of course, the disability would include everything from Social Security to veterans benefits, probate procedures, this type of thing. So we are truly invested in improving people's lives, and that's what we do.
Can you give us like a brief overview of what estate planning is, like, and why it's crucial for people, especially women, to have?
Absolutely. So estate planning is a fancy term, and people sometimes think that means that you have to have a lot of money. Every single one of us has an estate. We are our own estate, our person, our income that comes in, our cars, our bank accounts, our money that has to go out for bills, health insurance, all of this is considered part of our estate. So it is very important for people in general, but especially for women who are going through changes like divorce or having lost a spouse, to make sure that those pieces are in place so that they can retain autonomy over what's going to happen with them and with their things in the future, including our children. If we have minor children who are under our care or a disabled adult child who are under our care, we have to make those decisions proactively and put it in writing in order for us to have the autonomy to make those decisions. Not making the decisions and not putting it in place means somebody else is going to do that for us. And we don't want to give up that control.
No, okay, I love that. So you said you don't need to have a lot of money to do this. So in order for just like your average person that is sitting here thinking, yeah, okay, that's for those rich people. What are the qualities that women should look for in an estate planning attorney, or so that way they can figure out if this is the right fit for them, or if this person knows what they're talking about, or any of that kind of stuff?
So the first and foremost thing is you got to choose somebody that you're comfortable with. Just like choosing a doctor, if you don't have trust in them, you're not going to listen to their advice, you're not going to follow it. So choose somebody you're comfortable with. The second thing is choose somebody who's going to listen to you about your situation, because cookie cutter estate plans will not serve a good purpose. You want to make sure that they're listening to you about your family dynamics, about what's important, about what your aspirations are for the future and for the future of your family. Those kinds of things, if they are implemented in an estate plan, will serve you much better.
Okay. Okay. So you have to like the person. So not don't just go by
Mhm.
what your friend tells you. If you go in there and you don't get a good vibe, then find a different attorney.
Exactly.
Okay. That makes sense. It's a simple thing, but it is hard. I think most people, when you start talking about the law, we get overwhelmed and we feel like it's a scary process and we don't think that we can not like this person and pick someone else. So I
Right.
think that can be an issue. So I love that you mentioned that first and foremost is being comfortable, which is, I don't know. I don't know. That would have been the first thing I would have thought to say. So this is why you're the expert.
Well, and I find too that sometimes people come into my office, they've never met with an attorney before, and it's easy for a person in that situation to just go, oh, okay, you're the expert, and blindly follow what's being said. No, we're all thinking analytical people. We need to make sure that what is being told to us is something that makes logical sense to us. And if that's not the right fit, don't stay.
Perfect. Okay, I love that. So permission to leave, which
Yes.
we all love. It is critical. Now, here's a question that I wanted to ask you too, is like, what are some common misconceptions about estate planning that you run into? Like, how can women avoid those pitfalls?
Sure. So we talked about one already.
Hmm.
Everybody has an estate. Everybody should do this. So don't think you have too little money. And also don't fall into the opposite trap, which is everybody needs a trust, because not everybody needs a trust. They are very valuable tools in estate planning, and we can accomplish some good things with them, but not everybody needs one.
Okay, because I know in the online space right now, there's a lot of talk about everyone needs to get a trust and you put everything in the trust and then this whole thing, but no one really knows what a trust is. So can you tell us what a trust is?
Absolutely. In its most basic form, a trust is a contract. It's a contract between the person who is setting this up and putting their money into it and the person who's going to be managing that money for them in the future.
Okay.
And that contract contains a set of instructions about how you want them to manage it. How do you want them investing it? Who gets the money? At what time do they get the money? How can the money be used before the beneficiaries get the bulk of the money? All of these things. It sets out the regulations and the statutes for the state where it's being created to say what the trustee can and cannot do. So it's a very, usually, it should be a very inclusive document of all of those things. But like I say, in its very basic form, it's, I have money, I'm setting up this set of rules. Will you agree to manage it for me? And that's the basic.
Okay. Okay. That's awesome. Okay. So now people know what a trust is, and you can see why you wouldn't necessarily need that. And is it more of does it depend on your assets, like how much assets you have, if you should have a trust or not, or your personal preference? Does that matter?
So it involves a variety of factors. First of
Okay.
all, if you're leaving money to someone who cannot manage that money for themselves,
Mhm.
let's say they're a minor, or they're on governmental benefits for a disability, or they have an addiction or some type of a disability that would cause them to be vulnerable to end up with that amount of money or to blow through the money quickly. Those are times when you're going to want to use a trust. We also use them if we have a blended family where it's a second marriage, you've got kids from both of the prior marriages, and you want to make sure that everyone is fairly taken care of. So there are very specific times when those trusts are so very important. But other times, let's say you're a single person and you have two adult children and they're both doing great and they're both healthy, and you just want to put them on as beneficiary on your accounts or use a ladybird deed for your house. Perfectly fine. Those assets will flow to those people easily without going through probate. And it's actually easier to administer than having a full-blown trust.
Oh, I'm learning things today. Okay. I love that. Okay, that's really good to know. So flowing into that then, so what are some common estate planning challenges that women face after divorce? Because you mentioned just now like the blended families and then different children. So then how can they ensure that their personal and financial interests are protected like after their divorce and now she's a single woman, maybe she's got kids or who knows, but what does that look like for a woman after divorce?
Absolutely. The biggest thing is take that step to get your estate planning redone after the divorce is final. When you divorce, there's provisions in the law that say if you've named a spouse as a patient advocate or as a beneficiary, then those are automatically revoked at the time of the divorce,
Mhm.
except if it's a life insurance policy governed by ERISA. So if you have an employer who has provided you a life insurance policy, your prior spouse could still be on that. So you want to take that step. I know divorce is grueling. People come out of this emotionally drained, and usually sometimes financially drained, but
Mm-hmm.
it is so important to take that step and make sure going forward you have completely severed those ties and that you have the people who you want to make those decisions for you in place with authority.
Okay. All right. So make sure you're taking your ex off of your work sponsored insurance policies.
Yes.
Is critical. So it would only affect those work policies. So if you had policies outside of work and your ex was named as the beneficiary on those, would you have to, would it automatically be canceled or would they also still be the beneficiary on those policies?
No, if it's not an ERISA policy, if it's not through work, then those are automatically revoked. However, if you don't put somebody new on it, then that policy's got to go through probate when you pass away.
No. Okay. Yeah, we don't like that. And I know you've mentioned probate several times. Can you give us like, and I know it's like a big whole thing, but can you give us like a brief explanation of
Absolutely.
probate?
Absolutely. So when a person passes away, we look to see what assets have a joint owner on them. So if you own a house with somebody else, that person ends up most times being the full owner of that house if it's jointly titled. Then we look to see what assets have beneficiaries on them. So those life insurance policies, IRAs, that type of thing, sometimes bank accounts, those would go to the beneficiaries who are named. If something is titled to a trust or payable to a trust, those things go to the trustee and they handle the disbursement of those per the instructions in the trust. Probate covers anything that's left. So it's a catch-all for anything that's left. So if you had that life insurance policy and your former spouse, that beneficiary designation was expired with the divorce, and you don't have anybody on there, those life insurance that proceeds are going to have to go through probate before they can be cleared and passed on to your heirs.
Okay. And how long can that probate process take?
It can take anywhere from a minimum of 6 months to years. I have seen some of these go on for years because we've got real estate or a family farm or something complicated like that. Normally, it's a year to about a year and a half to get things fully administered.
Okay. So not having beneficiaries on your, at the bare minimum on your life insurance policies, then it has to go through probate and it sits there until it's been reviewed and figured out, and then it would be dispersed to like your next of kin? Or do people have to petition to have to be considered in the probate, or is it automatically to children or parents or
So if you have a will, then it goes according to the terms of your will,
mm-hmm.
right? There are some priority distributions that get made first. So funeral expenses, last disposition of bodily remains, that type of thing comes off the top. Then the costs of administration. So the attorneys get paid next.
Ah, I see.
Yeah.
Okay.
So you don't want to have to pay big attorney fees or fees for the court. The third thing is the exempt amounts that will go to a surviving spouse or children, and that can total quite a sum. Around $80,000 is what we're looking at right now as a total exemption if you have minor children and a spouse. If not, then those we skip over those. And then the next thing is creditors. So when you open a probate estate, you have to file in the newspaper and advertise for creditors. They have 4 months from the date of that publication to come forward with anything that they want to claim from your estate. This could be estate recovery if somebody was on long-term care Medicaid, which would usually wipe out the estate, or things like credit card debt, deficiency on an automobile loan if it went back to the creditor when you passed away, student loans. That's another thing that can come out of there. So just beware that by having to go through probate, by not having beneficiaries or having a trust, you're opening up those assets to everybody else coming in to get a piece of it.
Okay. Okay. So have beneficiaries is what I'm hearing. Have a
Yes,
will is the
yes,
second part of that. So
yes.
then that way the money that you have, your assets that you have can go to your family or friends or charity, wherever you want it to go, instead of going to all these other entities.
Exactly. You get to decide where it goes,
Yeah.
not the law.
Ooh. All right. Need to get our poop in a group. All right. We need to get it together. Okay, I love this. For new parents or single parents. So then what
Mhm.
are the essential estate planning steps that they should take to make sure that their children like get their assets if something were to happen to them, or even custody if you can dig into that a tiny bit?
Sure. With minor children, it's really important to make sure that there's someone in place to manage the assets for the minor children. If you leave them assets that go through probate or are they're listed as beneficiary on them, the court has to appoint a conservator to manage that money. By law, their other parent has priority to be the conservator over that money. If you've divorced and you share a child with your ex, you are going to want to make sure that you have set up that trust so that somebody that you choose is managing that money on behalf of your child, not your ex. Sometimes that works out. Most of the time, if you've been divorced, you don't really want that to happen. That would be number one. Make sure that you've got that trust set up. The other thing would be guardianship and custody matters. Now, if both parents still have parental rights and it's just a matter of preference that you want your child to go to another family member or a friend to be their guardian if you pass away, you can certainly express those wishes, and I would encourage people to express those wishes. Usually we put that in the will or a standalone document for nomination of guardianship, but you can't cut off the other parent's rights by setting that up. So if they step up and they say, no, I want to take custody, then that's usually what happens. Now, as our children get older, as they turn 13, 14, 15 years old, they can express to the court what they want as well. So if they don't want to be full time with their other parent, they can request the court appoint a guardian for them. And it doesn't
Okay.
have to be the same person that you've nominated in your will. It can be a person of their choosing.
Okay. Okay, that's good to know because I know as a divorced person myself, I that's a question that I had. What would happen to my child if something were to happen to me if she didn't want to go and stay full time with her dad? She doesn't do that now. So then how does that work? So you can, especially when they're older, they can have a little bit more say, which is nice to know.
Yes.
Okay. Fascinating. But you do get to have you can at least put your wishes out there, which is helpful. That is a nice thing to know because I didn't think the court would necessarily take that into account.
Yes, they will. And of course, you don't know what life is going to bring for the other parent either. If they pass before you or were incapacitated, you want to be able to make sure your wishes are known.
Okay. Perfect. I love that. Okay. This is heavy, right? Like, this is heavy stuff. It makes you think
It is.
about all of the different pieces that we normally don't think about. So I appreciate that tidbit. Now my mind is going, so let me focus. Let me focus here. So now how important is it? So we've touched on beneficiaries a little bit. So how important is it to update your beneficiaries and other estate planning documents like after a major life event? So divorce, but also a big life job change, or if you move or you retire and now you're going to be like a nomad traveling around. I know it's important, but what are the steps that we should probably be taking when those things happen?
I would recommend that you review your estate plan and your beneficiary designations every 3 to 5 years because life has a tendency to go full speed ahead. We lose track of what it looked like when we set it up versus what's happened since then. So it's good just to pull them out, review them, make sure that you also pull them out and review them whenever there is a major life event like a birth, a death, a marriage, or a divorce of any of the people that you've named. So, for instance, if I have named, I don't know, let's say I named you, Ebony, as my trustee in my trust, and then you ended up, I don't know, adopting 3 kids. And you've got your daughter, and then you've got 3 more kids. And I would take a look at that and go, oh my goodness, I can't put this on Ebony. She's got way too much going on right now.
Okay.
Or I name my sister and my sister ends up with dementia. I want to make sure that I've got those documents updated so that somebody is in place ready to step in when I need them to step in.
That is okay. Yeah. Again, things I hadn't thought about. Like you figure, I think most people think you create that will and then you set it and then you forget it. Or maybe you look at it again because you got divorced, but you don't think about the people that you've named in
Mhm.
your will that will be helping distribute all of your assets and figure out all your stuff for you, or maybe watch your kids, right? Because maybe they're the person that's going to take over your kids for you. And like you said, now they've got like 6 of their own extra kids. Maybe they can't take your kids in. So here's a question then. So if I create a will and I have my copy, does my attorney keep a copy forever? Or is there like a time limit on how long your attorney keeps those documents? Like, how does that part work?
So that the answer to that question has evolved over the years. I think it used to be pretty standard that attorneys would keep the originals in their office. And then we ended up with a process where we can store those original wills with the local probate court. I think that's a good thing to do just so they don't get lost or unintentionally destroyed. Um, Normally, the attorney keeps a copy for a minimum of 10 years because we've got our ethics rules that tell us how long we have to keep our records. But with the advent of technology, scanning documents in, being able to easily store things, I'm finding that at least my office is keeping them for much longer.
Okay, okay. And then, so are you automatically registering every will with the probate court, or is that something that a person has to do as a separate, like, service or a separate line item that they need to do?
So again, every attorney's office is a little different.
Right.
In my office, we offer to do the footwork to get the will over to the court and get it recorded. There's a
Okay.
$25 fee that needs to be paid to the court. Usually the client gives us a check for that. Um, if they opt not to take it and not to have it go to the court, we generally have them take the original will with them. Now, a lot of times people think they should put them in safe deposit boxes in banks. That is problematic because if they pass away, it's hard to get access to that. And we usually have to petition the probate court for an order to drill open the box to get to it. Really slows things down, adds extra costs. So I tell people if you want to take it home, either leave it in the binder so that we know where to look for it,
Mhm.
or you can put it in a Ziploc bag in your freezer if you are worried about your house burning down, because
Mm,
the contents of the freezer won't incinerate generally in a fire. So that's one way to protect it if you want to take it home. But uh, house fires are not as big of an issue in modern times where we've got better safety. And the other thing is that if a will was unintentionally destroyed in a house fire, we can probate a copy. It's just going to take an extra step or two with the probate court.
okay. Okay. That's good to know. So it's like a backup for the backup's backup, putting it in
Exactly.
probate. So then
Yep.
you know it is there and people, because I can imagine having it in your freezer, like maybe some person comes in, people pass away, and someone comes through, sees it in there and gets rid of it. And if no one knows it's there, right? People are nefarious. I don't know. But if it's not, I don't know where I'm going with this. I do. If so, if someone comes upon your will after you've passed away and they toss it, is there any recourse that your remaining family members or friends have to find it if it's not in the probate? They don't know that it exists.
If they know what attorney represented the
Okay.
person, then you can generally go back to them and ask for a copy.
Mm-hmm.
Or if the attorney does not feel comfortable releasing it to family members, if they don't have something in their file that says who they can release it to, then they can at least send a copy over to the probate court and say, you need to be aware of this.
Got it. Okay. Yeah, I got all creative there. But because I wonder, people do, you've seen, I'm
I,
sure, a lot of things, and people do some
yes.
squirrely stuff. And so it seems to me it would be a really good idea to register it with your local probate just to have it there as an extra situation. And then also too, I would assume if you're naming people as trustees or or naming people as beneficiaries or guardians. You would have spoken to people about your will. So we should probably be talking to people and say, hey, I have a will. This is where I keep all of my important documents. It's going to be in this place. Um, and so this is a reminder to do that, to tell people this is where that is. I know now they sell, because we have so many accounts and so many passwords and so many everything. I know with iPhones, you can designate an emergency contact person. So if you pass away, there is a person that can access your cloud and get into all of your documents. I would assume you can do that with Google and you can do that with these other services. Do you find that people put any of this type of information of these are all of my bank accounts and these are all of my life insurance policies, my investment accounts and things like that? Can that be a part of that, or is that always something that's separate just for like historical reference?
So when we finish an estate plan, we always put together a binder that has all of the documents that we've done, and then a couple of extra. We've got a memorandum for personal property that people may want to give to certain people, and then a couple of medical documents. One is a living will, the other is a do not resuscitate form that can be used if they wish. So we provide that, but there's plenty of room in that binder to add things like copies of your beneficiary designations on your life insurance or your IRA, deeds that maybe for property that you've purchased with somebody else, or that you've deeded into a trust. We can always add those as well. Yes, those can all be in one place. Sometimes people like to write letters to their funeral representative about what they want for their memorial or where they have their burial plot, those types of things. If it's all in one central place, then it's easy for the person who's either the personal representative or the trustee to be able to act on that quickly. We had the mailbox rule. So we tell people you have to probate an estate, watch the mail for 30 to 60 days because you'll get all the bank statements that come in that you'll need to, for accounts that you need to deal with. Now, so much of it is online, we can't rely on the mailbox rule. So having that list makes it a lot easier.
Okay. Okay. And then flowing into that with as things have changed and evolved technologically as women age, right? Women, we're living longer because we're cool like that. And what are some key estate planning issues that we should focus on as women as we age, so that we can make sure that our wishes are respected as we grow older?
Absolutely. So one of the things is to make sure that you have someone named in a patient advocate designation. It's also called a medical power of attorney.
Mhm.
Here in Michigan, and this is probably the one area where the 50 states differ the most. Medical powers of attorney are the document that we use here in Michigan as our official document. It names a person rather than giving a set of instructions about what you would or would not want for your care. Now, that was intentional that it was set up that way because, as we all know, just having come out of a pandemic, we never know what's around the next corner as far as health issues that could come up or treatment options.
Mhm.
So we want somebody who is named with authority to make those decisions in real time for us so that they can hear all of the ins and outs of what's going on medically, what options are out there, what long-term care placement options are out there, because that is another industry that's evolving very quickly. So the power of attorney, the patient advocate designation, lists a person to make those decisions for us. We usually name a second person in case the first one is not able to serve for some reason. And then it sets the outer parameters of what that person can make decisions about. Do they have authority to make a decision about life support or life sustaining treatment? Do they have the ability to authorize hospice care, organ and tissue donation, mental health treatment? Those are broad categories that we address specifically in the power of attorney to make sure that the patient advocate knows how to stay in their own lane, so to speak.
Right. Okay. Oh, okay. Yeah. Long-term care. I forgot about that.
Yep.
So as we're looking at it, so what about situations where So you've lived your life as a single woman for a lot of time, like not you personally, but you know, the royal you. And so you now get married later in life. What happens to your assets? Say you already own a home or other properties. Do those automatically go to, and then you pass away? Do those automatically go to your new spouse? Or is that something that, if there is no will, does it have to go through probate, or does it automatically go to that new partner?
So if you're married when you pass away, it does not matter how long you've been married. It could be 2 days, a day. It's still, that is your surviving spouse. And if you have no will and you have no descendants, so children, grandchildren, that type of thing, that is the person who would receive your assets, unless you have drafted a will, drafted and signed a will specifying where you want those assets to go. Or, of course, if you have beneficiaries or joint owners on those accounts.
Okay. So if I think sometimes people think, oh, I already had this property, I already had this stuff before the marriage, so my kids can have it because I had it before. But that doesn't necessarily mean that's what's going to happen. So if you remarry and you don't have a will, your new spouse could just take all your stuff and not give anything to your kids.
If you have kids,
Okay.
that's a different scenario. But if you
Okay.
have no kids, it all goes to your spouse.
Okay. Have
A
kids.
spouse and kids, and you have no will, then
Right.
there are provisions in how those in the law about how those assets get divided between the kids and the spouse. The
Hmm.
spouse will get the lion's share of it, but the kids will still get something.
Okay. Okay. And now but it would have to go through probate because there was no will. So then
Well,
everybody
they
else
would have to go through probate because there were no.
beneficiaries on the stuff.
Yeah, yeah.
Okay.
So having a will still means you have to go through probate for those
Right.
assets that don't have a beneficiary, but you get to decide where
Where it
things go,
goes.
not so much the law.
Okay.
There's-
Okay. While people are out here rebuilding their lives and being really happy, they need to make sure that they're being clear about what they want to happen with their assets.
Yes, and set up those beneficiary designations.
Beneficiary designations on all of your accounts and all of those. Because I know people don't think about their bank accounts as a thing. And I know that gets to be an issue, especially if you have joint accounts with people, then that becomes a thing. I think sometimes I've seen people that have divorced, they keep a joint account so they can transfer money back and forth. But then if the money that's in there and one of you passes away, then it's going to automatically go to that joint holder. That I know. But if you have your own lion's share of your savings accounts and your checking accounts that are just yours and you have no beneficiaries, that's going to go into probate.
Correct.
And so that money's going to sit there for maybe a year and might get wiped out by all of your other creditors and attorney fees and state fees and all of that.
Exactly.
Okay.
Exactly. The
Well,
other thing about joint accounts is that sometimes as we age, we think, oh, I'm just going to put my child on my account, my adult child, because it'll be easy for them to get to the money if something happens to me. But the problem is, I see this so often where people come in and they say, I want everything going equally to my 4 kids. And I say, okay, what do you have on your bank account? Oh, my daughter's joined on that with me. My daughter's joined on the savings account. And I left my IRA to my daughter because she's going to know what to do with it. That's great. But then all that money is going to go to the daughter and it won't be split between the 4.
right.
And if the daughter ends up with liability, like a car accident that she caused, or let's say the daughter is an obstetrician and ends up getting sued, that money could be at risk.
Wow.
Yeah. So
Okay.
the better practice is to use a power of attorney for them to have access to the money. It protects it. It keeps that shield in place between you have access, but it's not your money.
Right.
And then use the beneficiary designations to make sure it gets to the people you want it to go to upon your passing.
Okay. So okay. So you would have the designation. So you would have the power of attorney that has the beneficiary designation. Or are you saying you have the power of attorney and you have the 4 people named on the account?
Yes, the second.
Second one.
You want to make sure
Okay.
the power of attorney gives authority to access the money to pay bills, to use the money as the parent in this
Right.
scenario has directed you to use it, but it doesn't become that person's money. And the power of attorney only lasts until the principal passes away. So in this scenario, if it's mom's power of attorney giving authority to daughter can act on her behalf until mom dies, that power of attorney disappears. And from then on, it's the beneficiary designations. If there aren't any, then it's the will that governs.
Oh, that is an interesting sort of stair step situation that I just don't think anyone is thinking about. Besides you, of course, right? But most people aren't thinking about it. And then that's how you end up hearing those horror stories of people who their loved one passes away and now were left with nothing because everything was eaten up and the person thought they were doing a good thing by just adding them as a beneficiary, but they didn't have the other parts or the other people that would need to be added on there as well.
Exactly.
Interesting. Okay. All right. All right, a couple more questions for you. This is great.
Okay.
So now, how should women approach managing and protecting inherited assets, right? So especially if they're rebuilding like after a divorce or someone passes away, right? So someone passes away and now you have another house, you have a boat, I don't know, you have a vacation home in Belize or whatever. Like how do you manage that and protect that within your estate now that it's yours?
So the most important thing is to keep that segregated from joint assets with your new spouse, okay, or with your spouse. If you've received an account, you want to make sure that account is in your name alone, that you don't take that money and put it into a joint account and then move it to an account in your own name. It goes immediately from the person you're inheriting it from into an account in your own name alone. Now, this is where those beneficiary designations can come in. So let's say that it's legacy money that the parent left it to the mom, and she wants to make sure it goes on to her children, not to her spouse or her stepchildren. Naming those children as beneficiaries on that will keep it from passing over to the spouse and to stepchildren in that situation.
Oh, I love that. So that way, because I know people, and I did know about not mingling it with your other joint person. I knew that. But I think people, they don't see anything wrong with it, or maybe they only have one account and it's a joint account. And then they get this life insurance policy from a parent or like bank accounts or investment accounts. And then they immediately put that into their account. And now those are marital assets, right? So
Right.
those would be subject if you're getting divorced or if that person empties that account or whatever that is. Now it's too bad, there's nothing you can do about it, and that person could take that money in the event that you passed away. Then now they have all of that money and don't have to do what you told them to do or what you would have wanted to do with it, which is give it to your particular children or charities or whatever, if you didn't name them as beneficiaries and you didn't have a will.
Exactly.
Ooh.
And remember, if you have a will, it still has to go through probate. So those beneficiary designations is where it really protects.
And then they would get it immediately.
Yes.
Okay. I know with life insurance, it is an immediate dispersal once you have the death certificate, right? And it goes to
Right.
whomever it is that was designated, and there's no taxes on that. And so we haven't talked about taxes, but when you are inheriting, say you do inherit a house or you do inherit a bank account that has a lot of money in it, do you have to pay taxes on those things?
So the short answer is it depends.
I know life insurance is there's no tax on life insurance.
No. No.
Right.
So there's no income tax on receiving any assets as an inheritance. However, if you inherit an IRA or a SEP or 401k or any of those kind of tax deferred assets, you will be responsible for paying taxes on monies that are withdrawn
Right.
as you withdraw them. Okay,
Okay.
and usually there are options. Check with your financial advisor, your tax advisor. Usually there are options to be able to draw those down over a period of years so that you're not taking one lump sum and taking a big hit on the income taxes on that.
Right.
So that's the income tax side. The other, another tax that we have to look at is estate tax. Now, the person who passes away can pass, it's a little over $13 million right now per person. Be
Mm-hmm.
a nice problem to have, right? That talking about that home in Belize. If that person who passes away has more than $13 million, there's going to be estate tax return that needs to be filed and possibly some estate taxes, but that would be on the estate to pay those, not the recipient of that money. That should be taken care of prior to the money coming to the beneficiary. Another thing that we have to worry about by way of taxes is capital gains.
Mm-hmm.
So if you inherit a house and that house was appreciated in value $100,000 from the point at which the person had bought it, if they sold it during their lifetime, the capital gains portion would be the portion over and above what they paid for it and any improvements they made up to the value that they sold it for. Now, if it's our primary residence, we've got some exemptions. We get into the weeds with that, but that's the general rule. If you inherit a property or you inherit an account that has capital gains, like an investment account, that wipes out all of those capital gains that accrued during that person's lifetime. And the new basis for taxes becomes the value on the date of death. Okay. So
Oh,
let me use an example. If I had an account, I set it up with $50,000 during my lifetime, it doubled in value. So when I pass away, I leave it to my kids, it's $100,000. They don't have to pay capital gains on that $50,000 worth of gains. They get the new basis of 100,000. Okay. And if they then cash it in when it's 125,000, they pay capital gains on the 25,000. So it is a really big benefit
yeah.
to inherit something that has capital gains. Another thing that we look at for taxes when we inherit things is if you inherit a home that has homestead taxes in Michigan,
Mm-hmm.
and you are within a certain degree of family relationship of that person who passed away, you're intending to use it as a home going forward, it does not uncap the property taxes. So you get that lowered homestead tax from way back when the taxes were set.
Oh,
Okay.
wow.
Yeah. So when you own a property, they can only increase it so much per
Right.
year for the
Mm-hmm.
assessment. It's not going to uncap that. You also don't have to pay transfer tax on that because it's an
Okay.
inherited property. You get some really good tax benefits on things that are inherited.
Okay.
Sometimes people think, I want to make sure that my child gets this house. Maybe they're living with the parent and they're contributing to the maintenance and whatever. And the parent decides they want to put their child's name on the house during their lifetime. You disrupt all of those good benefits with the taxes. So be really
Oh.
careful about that.
Oh, wow. And this is why it's important to speak to an estate planning attorney before you start making these changes, because I did not know that. That's fascinating. Okay, so now I know one of the things that people do, and we're getting close to time, but I know one of the things that people do is they inherit their grandma's house or their parents' house, and then they sell the house. Would they then be responsible for capital gains on that, or is it be like they left them the house and they decide to sell the house? Would they be responsible for capital gains then when they sell it? So if it was like a $200,000 house, but the person bought it for $100,000, or like you mentioned earlier, does that wipe it out because it was an inherited property, so they would only be responsible if they sold it now for $300,000, or does that not work that
Yeah,
way?
yes, you're correct. It wipes
Oh,
that out. So it resets the value of the measure that we
mm-hmm.
use for capital gains to the value on the date of that person's passing. So when it wipes out everything that accrued during their lifetime as far
Okay.
as basis for capital gains. If you sell it within 6 months of inheriting it, then it's presumed to be the same value as on the date of death. But if you're going to hang on to it for any length of time, and this goes for stocks and bonds, investment portfolios as well, you're going to want to somehow document what the value was on the date of their death, because in 5 years, it's going to be really difficult to go back and establish what that tax basis is. So just make a record of it and keep
Right.
it in your files.
Fascinating. Okay. I love that. That is really, I'm so glad we're having this talk today. All right. And so my final question for you is, how can women educate themselves about estate planning so that they can make informed decisions, so they can feel empowered while they're trying to manage all of the moving parts, so that their loved ones don't have a whole lot to do when they pass away?
So the internet is a double-edged sword. It's a great place to learn about basic concepts, but there's also a lot of marketing out there, scare tactics, misinformation. Sometimes you're reading something and you realize it's based on California law versus the
Yeah.
state you're living in.
Yeah.
So you got to be a good consumer when you're reading that and sort through all of the things that don't matter or aren't good advice. I would say be careful of taking advice from neighbors and family members and just going, oh, they did this, so I'm going to do this, because every situation is individual and different. I would say don't be afraid to go and consult with an attorney. Again, a lot of times people may feel intimidated because they've never had that experience before. We're just people. But you pick somebody good, they're going to sit down and talk with you about what's important to you. And the other thing that people fear is they're going to walk out with a huge bill.
Yeah.
Ask when you set up the appointment, what is this initial appointment going to cost me?
Mm-hmm.
They may not be able to say what the whole estate planning package is going to cost going forward, but at least you'll know what you're committed to for going in for that one appointment. Sometimes it's free, sometimes there's a small fee, sometimes people charge their hourly rate. Sometimes they say, come in and talk to me. If you go forward with the estate planning, we won't charge you for the initial consultation. So everybody is a little different. There are some employers that offer legal services insurance, like I know University of Michigan does. I think some of the big automakers still offer that. And so that's a good way to get some planning done if you have a very basic estate that you're taking a look at, or you want to make sure is covered. So there are different ways out there to get educated. Seminars, be aware that's another double-edged sword. There's no such thing as a free lunch. If you go to one of those free lunches and you're there to gather information and you have enough self-control to walk out without signing up, that's probably fine. But I would say if you go to a free lunch, make sure you do not sign up. Go home and think about it. Talk with your friends and family and trusted advisors, maybe have a second opinion before you go forward. Some of those are very legitimate with good attorneys, and some of them are what we refer to as trust mills. Everybody gets the same documents with exactly the same language, and it doesn't consider the person's personal needs or wishes at all. So you got to be careful.
Okay. And so I think my final question is so say a person they've sat down with their attorney for that initial consultation and they said, okay, these are the things I want, and you've gotten an idea of what you need to do. I think one of the things people think about is, this is going to cost me thousands and thousands of dollars and I can't do this. Is it okay? Or would you say, would a person be, let me get this together. Yeah, I'm thinking of this as I'm saying it, but would it make sense then to say, okay, these are things that I want, and this is what's most important to me. These are the things that I want to do. So I want to, this is what I can afford to pay. This is what we want to focus on first, like the core components, and then building it out later. Or are you thinking it's better to just make sure you have all of your bases covered from the beginning and move forward?
So again, that depends.
Yeah.
Because sometimes some of the documents we do are interrelated with other documents.
Okay.
So if we do a trust, we're going to do a special type of will called a pour over will. If we
Mhm.
don't do a trust, we're not doing the pour over will. It's a different type of will. So that could have an impact on it. Usually we can break down the estate plan into doing the powers of attorney first
Mhm.
and then coming back later to do the will and the trust, or just do a will and not do a trust until you're more flush and ready to do that. I would say that for a basic estate plan, you're probably looking at somewhere between $1,000 and $3,000, depending on if there's real estate or minor children, if we need a trust or don't need a trust. That's a broad range. I
Right.
understand. There are now products where you can apply for a line of credit, just like you can for getting a root canal or
Mhm.
medical treatment. There's a company called Affirm that we
Mhm.
use where that can be, you can pay as you go without having to come up with the money first. Of course, I always tell people, make sure you understand what the terms of that are, because there are
Yeah.
finance charges and that type of thing. And some attorneys are able to set up a payment plan so that you can get what you need and maybe pay for it over 3 or 4 months.
Got it.
So,
Okay. Okay. Speaking to your attorney, so then you can figure out what the next best way forward. I think people thought, or what I've heard people say is, I won't do that because I don't have a bunch of money to set this up right now. And they haven't taken the time to even speak to an attorney to figure out what their payment options are. So it's nice to know that there are these different ways that you can still get the coverage and protection that you need for yourself and your family. And maybe step that out a few payments over time if you need to, or understanding that there's different types of things that you might need. So that way you can make sure you have what you need and not be worried about the cost.
yes.
Perfect. I love it. Thank you so much. This
Yes.
has been a fantastic conversation. And I will link your information so people can reach out to you if they're like, hey, I saw this thing and I'd like to talk to you about estate planning. And I know you have a crew of people now in your law office.
There are
So
15 of us now. So.
I just love that so much. So people would be able to, if they wanted to reach out to you, they can definitely do that. So I'll be listing that down with this video wherever it will reside. So then they can reach out to you. Is there any parting things that you'd like to share with people before we go?
Final parting words are, if it's not down in writing, it's not going to happen. And other people are going to end up being in charge. So get it down in writing.
Yeah, I love that. Yeah, I can't say anything better than that.